Hello there, and thank you for listening to this Wills and Estate Planning seminar made available to you by Legal Resources. As an employee of either the city or the schools of Virginia Beach, you are offered a legal insurance benefit and an identity theft protection benefit. Legal Resources has partnered with the city and schools of Virginia Beach since 1992. Today, we are happy to have John Fletcher, a partner with one of our network law firms, Tabs Fletcher, with us to provide some vital information about wills and estate planning, a topic that we all need to be informed on. Mr. Fletcher has been in the private practice of law with the law firm of Tabs Fletcher in Norfolk, Virginia since 1978. Mr. Fletcher received both his undergraduate and law degrees from the College of William and Mary. He has been admitted to practice law in Virginia and North Carolina. With over 45 years of experience, Mr. Fletcher is versed on both sides of the courtroom. Currently, he concentrates in representing plaintiffs in personal injury and medical malpractice litigation and in criminal defense. However, he has years of experience in estate law as well. Mr. Fletcher has been named to Best Lawyers in America, Virginia Business Magazine's Legal Elite, and Virginia Super Lawyers. For this presentation, he collaborated with his colleague and fellow attorney at the firm, Ryan Graves. Without further ado, I hope you enjoyed this seminar on estate planning.
Hi, this is John Fletcher with the law firm of Tabs Fletcher in Norfolk, a legal resources participating law firm. I'm going to speak with you today about trusts and estates, wills, and estate planning, a topic that many people don't like to talk about or think about, but is nevertheless crucial for the well-being of your families and loved ones, as well as yourselves. My colleague, Ryan Graves, does most of our estate planning along with Bob Reed and myself. And we're happy to give you this presentation today. Specifically, we're going to discuss what happens to us and our belongings when we are no longer able to make decisions for ourselves, whether because we are suffering from a mental or physical infirmity or because we have passed away. We'll discuss what happens in that situation and how we can take control of it before it happens. Now, many of my clients, when they come in to discuss estate planning, will talk about how they have put this off for far too long, believing it to be a very involved process. But by the end of it, they are usually quite surprised at how quick and easy the process was, and they regret that they had not done it much sooner. And with the legal resources benefit, most if not all of the estate planning documents you will need are provided at no cost as a covered service, which is just one more reason not to put this off. As far as what documents are important to have in order, I'd like to break this into two sections. One, dealing with those documents that come into effect while you are still living but no longer able to make decisions on your own. And the second area will be those documents that come into effect after you die. Of those estate documents that come into effect while you are still living, there are two important ones that I'd like to discuss. The first is an advanced medical directive. In this document, you assign an agent to make medical decisions on your behalf in the event you become incapacitated. That incapacity can be due to any number of reasons, such as being in an accident and being unconscious and unable to communicate, such as being in a coma, or if you suffer some sort of cognitive decline, such as dementia or Alzheimer's. In any of these cases, an advanced medical directive lets you decide in advance who gets to make healthcare decisions on your behalf. And the second component to the advanced medical directive is if you fall into a persistent vegetative state, and it is concluded by two attending physicians that there's no reasonable likelihood of you coming out of this vegetative state, in your advanced medical directive, you may dictate what is to happen under those circumstances. You can direct that life support be maintained, that it be withdrawn after a period of time, or that it be left within your designated agent's discretion. The other important document to have in place to cover you in the event you become incapacitated is a durable general power of attorney. This document is similar to an advanced medical directive in that you choose an agent to act on your behalf in the event you become incapacitated. The difference between these documents is that, in a durable general power of attorney, you are empowering your agent to handle your finances, as opposed to making medical decisions. Now, I can't stress enough how important it is to have these documents in place. Without them, if you become incapacitated and a family member or loved one needs to make decisions on your behalf, they have to resort to the legal system in order to obtain such authority. This could involve filing a petition with the court, having an attorney appointed to represent you as the incapacitated person. A thorough investigation then takes place and a court hearing. This can be very expensive and a very drawn-out process. All of this can be avoided by simply having these two documents in place before you become incapacitated. In addition, you have the benefit of choosing who your agent will be, whereas if you do not have these documents in place when you become incapacitated, any person can petition the court to be appointed as your agent, which they refer to as a guardian and conservator. And the court may struggle with who the most appropriate person is. It may end up being someone that you yourself would have never selected as your agent. Having these documents lets you take control over who that agent will be and avoids the unnecessary expense and time of having the issue determined by the court through litigation. Okay, let's discuss now some important documents which deal with the handling of your estate after you pass away, specifically wills and trusts. But before we delve into these documents, it's good to know what happens if you pass away without having a will or trust in place. This scenario is called dying intestate or intestacy. It's the government's one-size-fits-all approach to distributing your estate or property when you don't have a will or trust directing how you want it to be divided. There are a few problems with this approach. One is that everyone's family dynamics are different, and the manner in which the state divides your property, if you die without a will or trust in place, may be inconsistent with what you would have wanted. The state may give a share of your property to a family member who you would have wanted to have a lesser or greater percentage, or no percentage at all. In addition, if you pass leaving children or grandchildren entitled to share in your estate, and they are minors, there is no way to distribute these funds directly to them without some adult going to court and asking to be appointed as that minor's trustee or fiduciary for the purpose of receipt and handling of those funds. And you have no control over who that adult may be. In addition, if you pass away without a will or trust, you have no input on who is to be in charge of your estate. Anyone can apply to the court to be put in charge of your estate, and the court will do its best to determine who the most appropriate is giving preference to spouses and certain family members, but again, it may not be the person you would have chosen. So how do we avoid all of this from happening? We have a will or trust set up. Now, depending on your individual circumstances, a will may be more appropriate or a trust may be a better option. If your assets exceed $12.06 million, trust may be a better option for you since your estate becomes subject to federal estate tax for any amounts beyond $12.06 million. First, $12.06 million is exempt from tax. So if your estate does exceed that amount, a trust can be utilized to minimize those tax consequences. On a side note, that threshold, that $12.06 million, is effective as of 2022, increased from $11.7 million in 2021. The amount has pretty steadily been ticking upward over the years, but you can't say now what the estate tax exemption will be at your passing. The trend has been an increase, not a decrease, so the amount will likely be higher at the time of your passing. But for most of us, our assets will not exceed $12 million at the time of our deaths, and therefore we would be entitled to federal estate tax exemption. For those of us that fall into this category, a will is likely the most appropriate option, but that can all be considered at the time you consult with your attorney. Okay, so let's talk about wills and what they accomplish. Your will direct which of your family members, friends, and charities will receive distributions from your estate, and what percentage or fixed dollar amount those persons or organizations will receive. In the will, you can make general bequests or gifts, such as all real property and all personal property going to a beneficiary or beneficiaries without designating specific property or amounts. Or you can make specific bequests, which would give a certain individual a particular piece of property or amount of money. You can also do a combination of these specific and general bequests. You may also direct in your will what is to become of your remains after you die. Typically, people will choose burial or cremation. However, some wish to donate their remains for science or for medical purposes. In such a case, your lawyer will prepare a separate document that gets recorded with the estate that reflects this choice. Another component of your will is the designation of who will handle your estate. The title for this position is administrator or executor of the estate. As I mentioned earlier, without a will, the court is left with making this determination. But with a will, you get to ensure that the person who is handling your estate is the person you want handling your estate. Now, if you have minor children, your will should include a provision of who their guardian will be in the event both parents pass away before they attain the age of majority. Also, if you have minor children, grandchildren, or others who have not reached the age of 18 when you die that you wish to include in your estate, you may designate a trustee who will manage their inheritance until they reach a certain age of your choosing. It may be someone other than the guardian. In this case, your attorney builds a trust provision into your will that sets out what the trustee can use the minor's funds towards. This can include such things as education, medical needs, or housing expenses. Now, once that beneficiary reaches a certain age, an age that you have determined, whatever funds remain then get distributed to that beneficiary outright. Another component of your will is a provision that addresses tangible personal property. This is what we call stuff, not real estate, not land, not houses, but cars, boats, personal property that you own at the time of your passing. In this provision, it will state that you may or may not choose to add a personal property list to your will. This is a list of individual items that you may want to go to certain individuals. It can be a collection of yours, a particular piece of jewelry, or any other item that you really want going to a specific person you have in mind. The benefit of this list is that it can be updated at any time of your choosing. You don't have to come into the law office and have everything redone if you decide to make changes to that list. You can always do it on your own at your leisure. The only requirement is that it be in your handwriting and not typed, so it can be authenticated as being yours. Remember, wills are a fully covered service if you are a legal resource member. So the next question is, how do you go about getting all of these documents in place? In this day and age, there are those who might make use of the internet and download and fill in a blank form will. These are fairly easy to fill in, but the problem with them doesn't surface until after you've passed away, and the person designated to handle your estate attempts to carry out its terms. There may be events in your life that the form will didn't properly address, or provisions that end up conflicting with one another, or are legally capable of different interpretations, all of which require, ultimately, a court to consider and rule on when there's a dispute amongst your beneficiaries. And trust me, this does happen. I can't tell you how many cases we've handled where someone tried to do their will or estate document through a fill-in-the-blank form, and once they pass, their family ends up paying the consequences by having to go through litigation to clear up these issues. This can all be avoided simply by having an attorney craft these documents on your behalf. And there is no reason not to, since most of the estate documents you'll need will be a covered benefit under your legal resources plan. So, we've discussed how you can distribute your assets through your will. This is what would be referred to as a probate transfer. I'd like to talk now about non-probate transfers, things that pass or fall outside of your will. One common example would be a bank account with a payable on death designation. Upon your passing, the person you have designated on your payable on death account simply has to show the death certificate to the bank, and that person can then receive the available funds. This makes it easier to quickly access funds, perhaps for funeral expenses or other pressing financial obligations. Another non-probate transfer would be for any accounts that provide a specific beneficiary designation, such as life insurance, shares of stock or retirement plans, such as 401ks, IRAs, or TSPs. The same process for the beneficiary to access these assets applies. You simply send the death certificate to the company or entity in question, and the asset will be released to the named beneficiary. Now, if any of your beneficiaries or alternate beneficiaries under these instruments are minors, this is yet another important reason to have a will. In this sort of scenario, where a beneficiary is a minor when you pass away, the life insurance proceeds or retirement funds may not be distributed to the minor beneficiary outright, and you most likely would not want them to be. If you do not have a will, then a court action will be required to designate an individual or trustee to receive and manage these funds on the minor's behalf. This can be quite costly and time-consuming. However, this can all be avoided by simply having a will. And under your beneficiary designation for life insurance or retirement, instead of naming the minor as the beneficiary, you simply name your estate as the beneficiary. This causes those funds to go into or through the will, which has a trustee already designated to handle any and all funds on the minor's behalf. This saves everyone involved a lot of headache and expense. Lastly, let me talk with you a minute about what to do after you have executed all of your estate documents. It is crucial that the original, not a copy, of your will be safeguarded, since the court will require the original rather than a copy to be submitted upon your passing. I recommend using either a fireproof safe or a safety deposit box. Either will ensure that the original is protected. It's also important to let your executor or administrator and your alternate executor and administrators know the location of your will, since when they actually need it, you obviously will not be around to locate it for them. And finally, it is very helpful to keep in one place copies of statements for each of your assets and each of your debts. For assets, this might include bank statements, retirement account statements, life insurance policies, deeds, and vehicle titles. For debts, this might include a mortgage statement, car loan statement, credit card bills, or any other bills you have coming in on a recurring basis. This will save your executor the task of turning your house upside down trying to gather these statements, and ensures that none of your assets are forgotten about. This has been an overview of estates and the important documents to consider when you're doing your estate planning. Now, every person's situation is unique. So when you meet with your attorney, the two of you will determine how to tailor these documents to address your individual needs. And as I mentioned earlier, the biggest step for most people is simply scheduling the appointment. Once you do, your lawyer will do the heavy lifting for you. And in the majority of cases, you'll be surprised at just how easy the process is. So, if you would like to contact me or my colleagues Ryan Graves or Bob Reed with additional questions, we are more than happy to answer them. I've provided our contact information for your reference. Email is usually the best way to reach us, but your calls are welcome. It's been a pleasure speaking with all of you.
Again, that was John Fletcher with the Legal Resources Network law firm Tabbs Fletcher, which is located on the 500 block of East Main Street in downtown Norfolk. To view all the local law firms in the Legal Resources Network, please go to our website at www.legalresources.com and click on our law firm finder, located in the middle of the homepage. With over 70% of Americans having a legal need each year, Legal Resources gives you and your family access to an attorney for all your legal needs. The average attorney in our area will cost you between $300 to $400 an hour, but with the Legal Resources legal benefit, you and your family will have your own attorney on retainer for only $204 for the entire year, which will be payroll deducted right out of your paycheck. For city employees, you will have 24 payroll deductions of $8.50, and for school employees, you will have 20 payroll deductions of $10.20. If you are interested in becoming a Legal Resources member, you can elect to enroll in the plan during open enrollment, as a new hire, or after a qualifying life event. And for more information on the legal plan or the identity theft protection plans, you can go to either your benefits website, our website at www.legalresources.com, or contact our award-winning Member Services Department directly. The department is fully staffed with certified paralegals and certified identity theft risk management specialists. They will be happy to answer any questions that you may have and at any time with around-the-clock monitoring of the phones. Thank you, and I hope you have a wonderful rest of the day.